Hello everyone, welcome to CashcroftTV. My name is Kalen Ashcroft. Thank you very much for watching this video on Guide to Legal History and Historians, where we will be covering all of the authors and chapters from the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. Today we will be covering chapters 25 and 26, The Return of Legal Realism and &law_society in historical legal research by chapter 26 by Dan Priel and Catherine L. Fisk, respectively. So as with all the others, please, these do not need to be watched in order. However, I recommend you watch the previous video on legal formalism, as I think that pairs very well with legal realism, particularly in the case of Dan Priel's chapter. However, I think these two fit very well together because I think law and society, which is the content of Catherine L. Fisk's chapter, fits very well, or is probably a natural progression from legal realism as discussed in Dan Priel's chapter. Furthermore, these videos are all done in the style of Plutarch's Lives, so at the end, before each chapter, there will be a brief biography of each legal scholar, and following that there will be a comparison at the end to hopefully perhaps learn more about them and the content of their research. So, without further ado, we will begin with the chapter and biography of Dan Priel. So this is in section 3, Perspectives, Legal History in Modern Legal Thought. This is chapter 25 of the Oxford Handbook of Legal History, The Return of Legal Realism by Dan Priel. So a quick biography of Dan Priel. He's a professor at Osgoode Hall Law School at York University, which is in Canada. And he's been a professor, or he's been there since 2011. Previously, in 2010 to 2011, he was a visiting professor. So before he became a professor in 2011 at both Osgoode, and simultaneously he was also an assistant professor at the University of Warwick in the United Kingdom. From 2005 to 2007, he was the Oscar M. Rubenhausen Fellow in Law at Yale Law School in the United States. As well, before that, he was a postgraduate at Oxford. He did his Bachelor of Law, his LLB, at the Hebrew University of Jerusalem in Israel. Then he did his Bachelor of Civil Law and Master of Philosophy and Doctor of Philosophy, all at Oxford University, the United Kingdom. He was a law clerk for the Supreme Court of Israel, and as well, during his time at the Hebrew University of Jerusalem, he was the co-editor-in-chief of the student-edited law journal at the Hebrew University. His current research interests include legal theory, private law, especially tort and restitution, and legal history and application of the social sciences, particularly psychology and legal research. His book is Institution in the Law, published by the Oxford University Press in 2006, and he has also published works in the Law and Philosophy, Legal Theory, Oxford Journal of Legal Studies, and the Texas Law Review, all journals, as well, and this work itself in the Oxford Handbook of Legal History, this chapter as well. So a lot of scholarship for a significant amount of work under Dan Priel's belt. So, as per his chapter, it's once again in part 3, Perspectives, Legal History in Modern Legal Thought. It's chapter 25 of the Oxford Handbook of Legal History, and it's titled The Return of Legal Realism. He notes that it was written at Osgoode Hall Law School, and he thanks the volume of editors and the workshop participants at the University of Toronto for the suggestions on the earlier draft of this chapter. So section 1 is titled The Mythology of Legal Realism. So he makes this comparison, and he says that, like nations, academic disciplines are imagined communities. And furthermore, like nations, they have histories of emancipation, not from foreign forces, but from oppressive ideas. And therefore, these ideas have founding fathers, which are semi-mythical heroes that as well. There are others, and there's those also opposed the scholarship, whether, as he notes, through self-interest, stupidity, or inertia holding it back. And this is all in the context of legal realism. And these may stand in the way of any sort of academic discipline. And therefore, he says, the founding narrative of American lawyers has the formalists as its villains, and as we'll see, perhaps legal realism as the heroes. Therefore, there's been a mechanical deduction, legal formalism is a form of mechanical deduction from legal principles that are waiting to be discovered. So if you watch my previous video on legal formalism, you'll understand it more, but it's kind of a mechanical process where there are definite legal principles that can be derived or that are waiting to be discovered through looking at the correct materials. But it perhaps neglects morals, politics, history, sociology, and psychology were seen as irrelevant to formalism, and therefore it was considered a wholly objective science. Then, however, he notes, came the young realists who challenged this, and at first these young realists were even compared to Nazis, and it was called a jurisprudence in despair. However, and it was later even rejected, but a generation later it began to bring back an order to the law, and ultimately it was widely accepted in the American Academic Lawyers Hall of Fame. So that's kind of the mythology of legal realism. It came out because the villains of the formalists, and then legal realism has now come to be in the Hall of Fame of legal academia. He also notes, however, that law has always been geographically bound, so this is also a national story. So it's a story of the American legal realists, and it's a mix of distinct American philosophy of pragmatism coupled with peculiar American obsession with expanding the domain of science to human affairs. But the caveat here is perhaps this legal realism story might not have parallel stories in other jurisdictions. And this legal realism displaced the distinctly European formalism, and it could be seen as a coming of age of the independent, self-sufficient legal system within the United States. It was pre-realist. The United States was based largely on English, German, French sources, and Italian as well. However, the realists no longer saw much that these systems had much to offer, so legal realism kind of was, as he says, a coming-of-age story for the United States legal academic field. And it also brought with it an extraordinary optimism towards the United States common law. He notes how surprisingly recent it is. In 1961, however, Grant Gilmore spoke of it in past tense. However, it was only very new at this time, as did the founding fathers of legal realism, such as Thurman Arnold, Hessel Netma, and Carl Llewellyn, and before, so they all started almost instantaneously speaking of it in the past tense. And they all saw, however, it as a cure of the crisis of formalism, whether explicitly stating it or not. In the same year, in 1961, in a review of Llewellyn's common law tradition, Walter Gellhorn said, "We are all realists now." So this is why it's surprising, is the fact that by 1961, when it was still yet new, as we'll see, it probably came from Roscoe Pound in the earlier, maybe the 1920s, early 20th century, pardon me. But by the 1961, Gellhorn says that we are all realists now. So within maybe perhaps 40 years, a little over 40 years, almost everyone went from this non-existing field of academia to everyone being included in it or prescribing to it. And but it was not, and therefore it was not over, however, but it was always relevant as well. So legal realism wasn't just done, but it still continues to today, as we'll see, particularly in the next chapter by Catherine L. Fisk. He has observed, however, that it waxes in periods of discord. So it doesn't do it does better in periods of discords, such as in the 1930s and 1970s, and it has waned in prosperity in the 1950s and 1980s. So perhaps, at least according to this thesis, realism fluctuates with the economic state of the United States. Few exceptions aside, everyone wanted to be on this realist bandwagon, and it was but he notes what was in the bandwagon varied. Some were legal positivists, some rejected legal positivism, some were natural lawyers, some adopters of efficiency as a normative standard, and promoters of ideas of the market regulation. Others were critics of these ideas. Some were pioneers of social scientific approach, or some represented humanistic bent of historicism. There was also an early incarnation of critical legal studies included in some, whereas others were interested in fundamentally different or opposed to critical legal studies. So probably one of the main conclusions that I hope you take away with this chapter is, although we might prescribe to Gellhorn's statement that we're all realists now, and we're perhaps all in this bandwagon, there's a lot of deviation in what realists actually are. Realists are often described as modernists or instrumentalists, pragmatists, and skeptists. There's perhaps no coherence in the descriptions, however. There's also a distinction must be made between old legal realism and new legal realism. So what really is realism if there's so much deviation? And it inevitably already comes in different flavors, he says. So therefore, what is this realist puzzle? Well, there are 4 possible explanations that are not mutually exclusive. A is that the realist ideas were banal and obvious. B, that they identified something fundamental all contemporary legal scholars now accept. C, different people identified in realists whatever they had already believed, causing such deviation. Or D, the realists were less consistent than people commonly assumed. Little discussion is currently on this puzzle, however, he notes, so that's why he's made it his task to cover it. So there are some of these causes that might have caused this large deviation in the types of realists we see and why there is no coherence. And in my estimation, all of them are true, perhaps to varying extents, however. So a little bit more detail. So A, that ideas were banal and obvious, is that it rejects realist creation myth. Example, so it was already existed. So there's an important scholar called Brian Tamaha, and he applied a historical approach where he unearthed realist-like ideas prior to when the Roscoe Pound actually founded realism in. So he traces back in history and shows realist sentiment in the formalist approach. So perhaps realism has always existed, so it's nothing new and it doesn't really even exist. And also even into prior to formalism times as well. But particularly his work is mostly formalism, because starting with Langdell, who incorporated the case method to Harvard Law School, is probably the inception of formalism. And therefore it was somewhat, this new realism was unoriginal and it already existed, they just changed the name. And it was therefore self-aggrandizing. And therefore realists were belated for obstructing the order, and therefore, but the Tamaha must be questioned. For example, Llewellyn said who is perhaps the most well-known realist, wrote an article, Some Realism, about realism, and who is responding to Dean Pound's none of these ideas are new. So Dean Pound, who actually was probably the first one, or the one who founded realism, said that none of these ideas were new. But then a later realist responds to him by showing what was new was putting it into a single package. So perhaps these ideas had already existed, perhaps dispersed throughout the formalists, but Llewellyn shows that putting it into a package was the founding of legal realism. And therefore, what he called consistently, persistently, and insistingly to carry them through. And sometimes this is all it takes for intellectual prosperity. And Tamaha neglects this also, the international background too, so that there was perhaps a response to particularly Germany and authoritarianism, but also in Germany there was a link between the law schools, and it was more interdisciplinary. But going back to the point that also another criticism is that if, against Tamaha, is if realism had already existed, how come it only started getting criticized later? And that was because it was put into a package, which I think is sufficient to call it a new thing. And it's not just against Christopher Columbus, Langdell, and Joseph Beale, but also German conceptualism. So it was also in a backdrop of what was going on in the international sphere. So therefore, if these things did not exist prior to realism, therefore how could realism have existed if it was a response to particularly German conceptualism? It was also against the backdrop and exaggeration for Tamaha to say realism or formalism was a distinction empty of independent meaning. Then moving to the second option, in that there was something fundamental all contemporaries accept, so it was just they all agreed upon it, so it was accepted. This distinction, it's in the fact that they're all not formalists. But Brian Simpson says formalism has little more than a loosely employed term of abuse. So if formalism doesn't even exist, how can realism exist if the only thing realism is a contrast to formalism? Dan Priel shows that the autonomy of law, especially the separation of law from politics, was the defining feature, however, of formalism. So he gives it a definition, therefore realism exists. And he understands that not a conceptual claim, but a normative one, so it's not a perfect definition, but nonetheless it exists. And therefore, for realism, law does not depend for its existence, significance, or intellectual livelihood on being autonomous. So that's perhaps one of the primary distinctions between legal formalism and legal realism, is that legal formalism is autonomous and legal realism is not, and depends on other factors. And therefore it's a negative thesis, and that this wide proliferation of there's a wide proliferation of positive definitions, but there seems to be only one negative definition that Dan Priel favors, and I like as well. And this has caused moving to C, the third point, that different people identified in realists whatever they already believe. So there's no manifesto of legal realism, so there's no specific definition of realism, and therefore there's different rules, concepts, principles, policies, and positions. For example, was Benjamin Cardozo a realist? Was Jerome Frank a central or marginal realist? So to what degree, who is a realist if there is no central manifesto? And once realists were canonized as revolutionaries of American law, inevitably whatever was important was traced back to realism. So once one was considered a realist, was all their work necessarily realist? Were they, it's not an absolute, like Roscoe Pound was probably likely the first realist, but was he an absolute realist? He said, for example, that all these ideas had already existed, but he didn't wasn't the one to entirely package it. So was he really entirely a realist? In fact, he actually did have some formalist ideas as well. Therefore, if legal realism means whatever one wants it to mean, it means nothing. But for each modern interpreter has their own definition, and there are too many meanings. And the challenges, and they have challenging and competing accounts of what legal realism is. Furthermore, that quote, "We are all realists, if you wish, because realism is what I do." And that's something that is said by many people. And this diversity sympathizes with Daxbury's conclusion that realism is merely a mood and not a defined ideology. Therefore, it is this assumption that the most positive idea beyond the rejection of an autonomy of law that the author seeks to challenge. So the author here, Dan Priel, seeks to challenge that there is not actually a positive definition for what legal realism is, but the real only definition is that it is not the autonomy of law, it is not formalism. And he thinks Llewellyn was right when he said realists united only in negations, skepticisms, and curiosities. However, I note curiosities I do think is a positive factor, but Llewellyn did note, who was a primary realist, that the realists only united in their negations and skepticisms, which would be those against particularly formalism. Therefore, when it's positive, however, there are two different relations, and they're each coherent but at odds, not in detail, tacit, or emphasis, but fundamentally different set of views. So there are a couple positive definitions that he would like to present, but they are quite different, and they lead to fundamentally different set of views as well. And the rest of the chapter will show how on several issues these two camps held different views. And he says the success of realist brand today rests at least in part on this difference, and perhaps on the fact these differences have not been adequately acknowledged. So it's perhaps important that they haven't been fully acknowledged, but nonetheless, he says there are not, there are many perhaps positive definitions. He hones in on two that perhaps explains why there's so much deviation in legal realism, and how some legal realists have completely different conclusions about the same topics. So next section, section 2, the two legal realisms. So far, legal realism has been defined in negative terms, as we said, the autonomy of law, or not the autonomy of law. And to understand more clearly the two definitions, he breaks down law into two elements. One, the techniques of legal realism, such as identifying, ratio of a case, or distinguishing, etc. And two, the articulation of premises themselves. So I could think of the means and the end, or the means and the substance. It's my simplification of it, but probably perhaps not the best word, so stick to his definitions if you can. And the autonomy of law has both elements, so there is the process of reasoning and the substantive premises on which these conclusions rely. So the autonomy of law has both this method and this substance. So, and as we'll see, the two positive definitions have different takes on these, and they can be learned from legal materials themselves, and law is aspiring to the status of a rigorous science and a laboratory, or a law laboratory. That's specifically the method. And then the realist attack on formalism is more of a question of premise 2 than reasoning of process 1. But as we'll see, the two definitions of legal realism that Dan Priel notes are contrast legal formalism in different ways. Holmes, in his Path of the Law, was a rallying cry for realists, and in that the premises of legal argument not internal to law but dependent on prevailing social attitudes of a particular time and place. So Holmes is a very important legal realist in that incorporating the social factors into the law, which are neglected by legal formalism. But it's not syllogism itself, in that it insisted logic was essential to thinking rationally, but the error, however, was for formalists to believe merely to plug the materials into syllogism. So they're not denying that there are a logic to the law, but that's not all. There's also social factors that Holmes noted as a rallying cry for legal realists. But if the law is not only within, where does it come from? And therefore we get to the two camps. One source of reliable premises for legal analysis should be used for all other domains of human knowledge, namely empirical science. For this type continue to be a backward science as long as the premises are questioned. So the progress is achieved by abandoning unscientific processes, as a Felix Cohen. So these are called the scientific legal realists. So they're sort of incorporating the formalist element of a logic of thinking to legal realism. And then the second one would be they also reject law's autonomy, but they reject the view that the methods should or could be the source for alternative premises for the legal argument. And instead, they ultimately are a reflection of the values of the people. Therefore, by probing the values of the people, lawyers find the right answers to legal questions. It gives a more favorable law view of common law and its determinacy, and it sought to eliminate image of law as a pure science which exalted the elite inducted in law schools. Carl Llewellyn could be put in this camp. It was one of the best known realists because he believed law need not be replaced by science. An analysis of concrete controversy and a re-examination when new controversies arise is necessary. And furthermore, they need not dismiss methods of lawyers or distinguish and limit past cases. So in this form of legal realism, which we'll see is called traditional legal realism, they still enjoy doctrine. However, they're against the methods or the strict logic applied, whereas the scientific legal realists are perhaps against the sources of specific doctrine there, but they're in favor of the scientific method. So this will all make more sense later. These are two very complex terms, and as you said, they cannot be described in one sentence. I hope I'm trying to explain it as best as possible. But furthermore, in this second camp, the traditional legal realists, they do not dismiss the methods of lawyers, but they distinguish and limit past cases. And law is a fairly determinate, however, because it is doctrinal in terms of the content. But judges are not free to just decide whatever they want. They must apply certain doctrine, and they at their own pleasure, and they sought continuity of law and tradition and conservative streak, and therefore they're called traditional legal realists, versus the first camp, which we'll call scientific legal realists, or vice versa. But the point is, the traditional legal realists sought to maintain the content of the law, that doctrine, but in terms of the method, they're more flexible in that they're open to other social sciences or other scientific method, or perhaps even non-scientific methods, whereas the other camp, they're against just the old doctrines, just the case books, but they're in favor of applying the strict logic. So those are the two camps. But also, it must be noted, there's a spectrum on this legal doctrine versus legal realism, whereas the latter could be called lawyers' tradecraft, in that the scientific realists are more against legal doctrine. It must be noted, such as Felix Cohen. Llewellyn was perhaps in the second camp. The traditional legal scholars was less cold towards these contents, and casebooks sometimes hold things that are very important, he noted, that must not be lost, such as doctrinal clarity, conceptual precision, and sharpness of legal thought. So the second camp does favor these old texts. However, they're more flexible in the methods. Jerome Frank, who is considered a traditional legal realist, I believe that the judicial response to is almost completely predictable through the contents alone, so more doctrinal in terms of the content. There's also been an interdisciplinarity incorporated. Specifically, empirical studies are more supported by the scientific researchers, such as Underhill Moore, Walter Wheeler, Cook, and Yanetma, previously mentioned, whereas the traditionalists, such as Llewellyn and Frank, are more skeptical of these scientific methods as they dehumanize the religion of science. So they use science, but law is not a turn. They do not want law to turn into a science, as the scientific legal realists might favor. And it's more likely to turn to history, such as Rodin, or philosophy, religion, and music, such as Frank, and cultural anthropology, such as Llewellyn, than the natural sciences. So that's the traditional legal scholars are more flexible in the methods. In terms of education, the traditionalists are more favored to doctrine, such as Llewellyn's introductory The Bramble Bush and Frank's Lawyer's School, which he invented, which had incorporated more clinics and the removal of appellate decisions as central. So although appellate decisions are central, he wanted to focus even more on the older and more specific content. But then, on the other hand, the scientific legal realists wanted more scientific method in the law schools, such as Unetma and Oliphant looked to model law schools after the medical schools, which was they wanted a revolution from the isolation from the other sciences. Pardon me, the medical schools went through a revolution of isolation from the other sciences. So medical schools started incorporating more physics and biology, and as well apprenticeships such as blood tests and scientific diagnoses to replace the tongue gazing and guess. That's according to Oliphant's quote, tongue gazing and guess. So nonetheless, they're more flexible in their content. They incorporate physics and biology, but in terms of their method, the scientific method applying specific blood tests and scientific diagnoses, that is more strict. So they differed in terms of education, and that's why if we are all legal realists, how come there are different perspectives of which way the law school should go? So moving to section 3, called The Lure of Legal Formalism. So views of scientific legal realists may not be surprising. The views of traditional legal realists, by contrast, seem to call into question their claims to challenging legal formalists. So do the traditional legal realists sound like legal formalists if they're very doctrinal in their content? And that is legal doctrine, the common law, and legal determinacy, because if they're strict on their sources and it has this legal determinacy, which sounds very much like legal formalism, he notes. But he says, while I believe formalism is indefensible, it is important to give it its best hearing, and this is best explained in two related ways: epistemological and political, both explainable in the context of its time. So now he's saying why legal formalism came about in the first place and how that implied upon the traditional legal realists. So the epistemological reason for legal formalists was that there was the German invention of the modern research university, which caused the legal formalism. So I guess a way of also describing legal formalism is that they're doctrinal in their content and method, and they want based off the modern German research university. And therefore law needed to present itself as more scientific in the United States. And then there was also this political cause in that it needed to be autonomous to attain legal authority. So as noting Alexis de Tocqueville in Democracy in America, he says that the lawyers really do dominate the political class, but if it overlapped too much with the other fields, then it would lose its authority. So therefore it had to be doctrinal in its content and doctrinal in its method as well. And therefore formalism or bust for its survival at the time. But for all decision directed towards it, law's autonomy remains stable for both academic and popular discussion. So although it has, some do criticize this doctrinal element of legal formalism, their law does seem to be separate, and that's why, for example, one cannot pass the bar if they have not gone to the law school in the United States. It is very closed off in that sense, and therefore giving defense for legal formalism, but that as it applies to traditional legal scholarship, traditional legal realists. So it is impossible for judges to be entirely extract themselves from their background, opinions, and values, and therefore you need realism or law is illegitimate, but specifically traditional legal realism, but also scientific legal realism, because they have to be doctrinal either in their content or doctrinal in their method, and both have elements of legal formalism, but both are against legal formalism more primarily. Arthur Corbin, who could be seen as a traditional legal realist, said to focus more on cases as well as social factors. For example, when a judge is law unto himself, we shall criticize and recall and impeach and even hang him. So there has to be this certain doctrine, otherwise if the judge could just do whatever he wanted, he would not be a good judge, and according to Corbin, should even be hanged, perhaps. Back to formalism, it was a science of legal materials, however, the traditionalists rejected the former and accepted the latter. So they accepted the materials but rejected the methods, whereas the scientific legal realists accepted the former and rejected the latter, in that they accepted the scientific method, or even pushed it forward, but in terms of sticking to strict contents, they were against that. And therefore maintain a scientific aspiration, but not form of a closed autonomous legal science, therefore continuous with the natural sciences, and it would be morally wrong to believe only in internal coherence or logic. The social engineers, or law as an implement of social well-being, according to Cohen, or questions of values, which are important. So Cohen is, I would say, perhaps a legal realist. Perhaps he crosses both boundaries, but at least he's flexible in terms of values or his social factors. So I guess that would be, if we're discussing changes in content, that would be a traditional legal realist. And he says questions of value are in fact questions of fact, which would be therefore showing both an epistemological and political necessity of legal realism, and therefore improve the lives and authority of law. In he says one sentence inevitably leaves out much nuance, but in his endeavor, here's his attempt to put it into one sentence, the difference. Traditional legal realism premised on a particular view that law is a natural outgrowth of society, and scientific realists thought law as a conviction or contrivance, which is a skill to bring something about. So I think perhaps maybe Dan Priel can tell me if he doesn't like it this method, but I think that the traditional legal realists seem to be in favor of the contents but not the method, but of legal formalism, and the traditional scientific legal realists are in favor of the scientific method but against the strict contents, and therefore both are against the autonomy of the law, which is the negative definition of legal realism. And therefore the labels, if needed, he says the traditionalists are organic and the scientifics are mechanistic. Pardon me. Moving to section 4, so solving the puzzle. So if the account presented is correct, we have an answer to the realist puzzle. The immediate impetus is that legal realism is a response to the challenge of the teaching of law at the university in a specific time and place, that is the United States. So it's a response to this legal formalism, because legal formalism was needed for both the epistemological and political reasons. However, it was wrong to be entirely autonomous, so legal realists kind of criticized it on the two fundamental elements. Another sense, it reflects an attempt to explain authority of law in the modern state, and in a broader sense it is still relevant today, because it's a discussion of how autonomous or how much authority should law have. Typically, realism, the two most important tenets are adjudication and prediction theory, which he intentionally omitted. So legal realism is usually defined in its tenets on adjudication and prediction theory. Specifically on adjudication, it's part of a larger picture, he notes, in that, for example, the traditionalists felt the experience of real world law, judges, lawyers, and even lay people with a semi-articulate values need to be noted, whereas the scientific legal realists saw that lawyers' realities are missing those that came from the natural sciences. So one of the main factors of legal realism is that there is the discussion on adjudication, and therefore the reason he didn't focus on this primarily is because the two different camps of legal realists have different perspectives, specifically that the traditional legal realists thought that they're neglecting perhaps the social factors behind the judges, perhaps their own opinions and such. That's the content of their person, or so it's not just the law and the cases, whereas the scientific legal realists advocate that they perhaps are not sufficiently educated in the scientific methods. And therefore lawyers' realities are missing those that came from the natural sciences. That's the scientific legal realists. and the most reliable source for the realistic understanding of the world would be that which the scientific legal realists advocate. So they both have criticisms towards the adjudication, but they both are for different reasons. As for prediction theory, that is a discussion of how law affects a person, not considering ethics or morals underlying the law. It's relevant to both traditional legal realists and scientific legal realists in different ways. So how does law affect, or legal realism, one of the things is that it does affect humans, and it needs to consider ethics and morals. So, but he intentionally omitted these as the primary discussions of the chapter, because if we don't understand that there's two different distinct camps of legal realists, then it would have been impossible to discuss. So as for the scientific legal realists, they saw are in favor of law and economics, psychology, evolutionary biology, and neuroscience as manifest its approach, whereas sociological and cultural approaches are descendants of the traditional legal realists. So they also have different focuses in addition to the law itself. And you might see, for example, if someone is a law and economics professor, you might say, perhaps they're a scientific legal realist. Or if someone is a sociological or cultural legal professor, you might say, perhaps they're a traditional legal realist. But as once noted, there's also, it's a spectrum as well, even though they are distinct camps. And therefore, we are all realists now. It's not because they're all the same, but because the fundamental rift on this question. And therefore, it's this legitimacy through its touch with society is central to contemporary debates about the law, specifically in tort, evidence and regulation, and environmental risks, which are some of the subject of his own research and graduate research supervision as well. And he says these are not just differences in technique, two paths to the same point. They reflect philosophical differences in the authority of law. And therefore, he says, in a democratic society, the choice between them is unlikely to go away. So I thought that was absolutely fantastic chapter. I had learned a little bit about legal realism in the discussion of legal formalism, but having understood that these two camps really broke down what legal realists were. I think if there was someone who was both a traditional legal realist and a scientific legal realist, one who advocated for both doctrine and in the content of the law and specific scientific method, well, in fact, they'd be a formalist. But if they were against both, then perhaps they're not a lawyer at all, because there has to be some kind of structure of the law, especially for the epistemological and political reasons previously mentioned. So that is the very fascinating chapter by Dan Priel. You can discuss the chapter, and we'll talk more about him as well in the comparison. So in terms of the institution, he's at the Osgoode Hall Law School at York University in Canada, in Ontario, Canada, in Toronto, Canada. His position is professor since 2011. As for the logos, we have the Hebrew University of Jerusalem. He received his LLB. The university, and was also an editor on the Law Journal. The University of Oxford, where he received his Bachelor of Civil Law, his MPhil, his Master of Philosophy, and his Doctor of Philosophy, and Osgoode Hall Law School, where he currently teaches. The graduate research supervision includes legal theory, private law, specifically tort and restitution, welfare state and the law, history of legal ideas. Important to note, Canada is a welfare state, because you have no salary, you do get welfare. Suggested readings, Intuition in the Law, published by the Oxford University 2006, that's a book. And some of his articles include Evidence-Based Jurisprudence, an essay for Oxford, published by Osgoode Legal Studies research paper in 2020, as a research paper in 2020. Next article, Not All Law is an Artifact, Jurisprudence Meets the Common Law, published by the Oxford Journal of Legal Studies in 2018. Next, a review, Private Law, Commutative or Distributive, published by the Modern Law Review in 2014. And a chapter, Is There One Right Answer to the Question of the Nature of Law, published in The Philosophical Foundations of the Nature of Law, published by the Oxford University Press in 2013. So work under his belt, both before and after he's become a professor as well. As per the quotes, we have the founding narrative of American lawyers has the formalists as its villains. Next quote, in the end, light prevailed over darkness. The realists' ideas were widely accepted, and their names have been forever etched in the American Academic Lawyers Hall of Fame. So once again, touching on that, it's a specific national story, specifically America. Next quote, as law has always been a geographically bound discipline, this story is not just one about disciplinary emancipation, it is also a national one. Next quote, the way I presented the two realist camps and their different responses to the formalist idea of law's autonomy help explain realism's continuing relevance. In a democratic society, the choice between them is unlikely to go away. So very, very fascinating topic. I hope you learned a lot more about legal realism. Once again, this is in part 3, Perspectives, Legal History, and Modern Legal Thought, chapter 25, The Return of Legal Realism in the Oxford Handbook of Legal History. We'll learn a little bit more about Dan Priel as well in the comparison with Catherine L. Fisk for covering her chapter and biography. So, in terms of the biography of Catherine L. Fisk, she is the Barbara Nachtrieb Armstrong Professor of Law at the University of California, Berkeley School of Law. It's important to note that one of the editors of the Oxford Handbook of Legal History, Christopher Tomlins, is at the University of California, Berkeley. So, and as we'll see, she references Christopher Tomlins a few times in her chapter. I think they have at least some relation with each other. She received her A.B., her bachelor's degree, from Princeton University, where she was academic standing of summa cum laude, which is the highest, in 1983. She then received her Juris Doctor from the University of California, Berkeley, where she was the Order of Coif, which is the top 10% class, and graduating in 1986. So important to note that she went directly from her undergraduate degree to her law school. And then she also received a Master of Law from the University of Wisconsin in 1995. So a little while later, however, for the Master of Law. She clerked at the United States Court of Appeals, Ninth Circuit, which covers Central, East, North, South California, so basically everything but West California, Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, East and West Washington, Washington State, Guam, North Mariana Islands as a jurisdiction for the United States Ninth Circuit. So it's not always good to use the word prestigious, but it is a very difficult thing to become a clerk in the United States Court of Appeals. Before academia, she practiced civil appellate litigation and union-side labor law in Washington, D.C., and before joining the faculty of Berkeley Law School in 2017, she was on the law faculties at the University of California, Irvine, the University of Southern California, Duke University, and Loyola Law School of Los Angeles. So primarily in California, however, Duke is not. So, and she also was educated in the East as well. She also has significant public service and pro bono work, such as filing amicus briefs on various labor and employment law issues, and her service on advisory boards of the Berkeley Labor Center. She's also on the board of directors of the American Society for Legal History and the board of directors for 2 Bay Area workers' rights nonprofits, and she also has occasional service as an arbiter under collectively bargained contracts. She also teaches courses, and the courses she teaches and her research interests cover employment law, labor law, civil procedure, and understanding the U.S. legal profession. She's also the faculty director of the Berkeley Center for Law and Technology. Her books, she has many, but 2 of her own that I was able to find and that are referenced on her website. her first work, Working Knowledge, Employment Innovation and the Rise of Corporate Intellectual Property, from 1800 to 1900, published by the University of North Carolina Press in 2009 and republished in 2014, which won prizes from the American Society for Legal History and the American Historical Association. Her second book was Writing for Hire, Unions, Hollywood, and Madison Avenue, published by the Harvard University Press in 2016. She's also the co-author of 4 books, most recently including What Lawyers Do, Understanding the Many American Legal Practices, published with Anne Southward by West Academia Publishing in 2020. She also has over 100 of articles in publishing such as California Law Review, the Berkeley Journal of Employment and Labor Law, and the Harvard Law Review Forum, and the Yale Law Journal Forum. So lots of significant writing under her belt as well. So moving to her chapter itself, it is in section 3, Perspectives as well, Legal History in Modern Legal Thought. It is chapter 26. It's got the ampersand and a colon, Law, Society in Historical Legal Research. So we'll see it's got a very unique title, but it will all make sense so as we discuss it. So starting with section 1, the introduction. So she says, the origins of the ampersand in the law and society vis-a-vis historical legal research means at least 2 distinct though interrelated things. 1, law and society movement as the 1960s descendant of legal realism, as previously discussed, was a generation almost synonymous with interdisciplinary study of law in the U.S., and therefore applying to legal history, and was a branch of law and society, at least when more than historians deride as law office historians. So law office histories, which are just simplified tales of doctrinal origins and evolutions written by the court. And the second is that its law and society was an approach to legal history particularly associated with pioneering work of James Willard Hurst, beginning in the 1940s, when Hurst urged legal historians to examine law not in terms of doctrinal classification, but in terms of given economic or cultural functions or activity. Legal history, a research program. This was published in his writing, his article, Legal History, a Research Program, published by the Wisconsin Law Review in 1942. So there's these 2 distinct, though, meanings of what law and society is, but I think we'll see they're both correct. So there's, on the one hand, that it's a movement starting in the 1960s towards interdisciplinarity that encompassed legal history, and not legal history as a sort of doctrinal thing, but as an interdisciplinary legal history itself. And then also as this definition of by J. Willard Hurst, where that in the 1940s legal history historians needed to examine law not in terms of doctrinal classification, but in terms of economic or cultural function of activity. This will all make more sense very soon, I hope. In both cases, law and society has been so significant that no sophisticated work published in the last quarter century has escaped its influence. So law and society is everywhere, particularly, as we'll see, relevant in social legal history in this chapter. In the society half of the law and society dyad grew tremendously in the late 20th century and early 21st, as the growth of social legal history occurred at the same time as many disciplines had late century turns to history, such as historical sociology, history of political institutions, historicism in legal studies, and part of the late 20th century wave of historicism across social sciences and the humanities. So there's these underlying trends that have caused specifically the society element to grow. And there's also the lawyerly movement away from legal doctrine that characterized scholarship, which we could be seen as legal realism, excluding the legal realists. In the first half, so the legal realists were the ones who were against the legal doctrine. But as we saw previously, there are different camps that perhaps are in favor of doctrine on one side or the other of the coin. And so it was perhaps law and society was perhaps a movement in response to the legal formalists as a result of legal realism and the rise of empirical legal studies such as law and economics and growth of law professors with PhDs in sociology, anthropology, American studies, political science, economics, and history. So this large move towards interdisciplinarity in the legal studies. And this contributed to socio-legal history, in that society part of law and society enjoyed robust growth that could not but affect the way legal history was done. So this interdisciplinarity and this legal realism caused this particularly the growth in the society part of the dyad of law and society. Moving to the law side of law and society grew too with the rise of legal pluralism in the 1980s and 1990s, where they expanded scholars' conception of law and therefore exploded the possible studies of law. Hearst advocated a narrower range in 1942, where lawman's peculiar expertness to maintain it. So if law is getting too broad, then lawyers and legal academics are losing perhaps their expertness and dealing with primary sources. Therefore, legal history focuses on the arena of social life, with those who employ the power and act in the name of the politically organized community and economic problems, and did not, however, her statement that they should not overexpand did not seem to stop this expansion of legal pluralism. Catherine L. Fisk notes. And therefore, it's not formal law and economics only, which Hearst advocated. So Hearst kind of tried to hold back this trend of legal pluralism, saying it should stay with formal law and stay with economics, but it did not entirely hold it back. So therefore, we see a problem. If the dyad of law and society, if anything can count as law, such through legal pluralism, and society encompasses almost everything, such as interdisciplinarity, then what is law and society? If law is everything and society is everything, then it's a very murky distinction. So most law and society scholars channel Felix S. Cohen's legal realist aura in that it's a transcendental nonsense, and in his article titled "Transcendental Nonsense and Fundamental Functional Approach," published by the Columbia Law Review in 1935, in that nonsense law exists separate from society. So Felix S. Cohen says it's nonsense that law and society are separate, so why do we have this law and society? We'll see very soon. So therefore this and sign, or ampersand as it's called, instead should be thought as a manifesto for socio-legal studies generally and socio-legal history in particular. For legal historians, like scholars generally, ought not just to study treaties, statutes, and cases, and not seek only logic and meaning of reasoning of judges and lawyers, and set sights more widely on how legal systems are used to pursue an end, and what contracting parties do, social, political, cultural landscapes of criminal courts or property disputes, or debtors' prisons, or how family members take or seek power using legal claims. So perhaps this law and society is a call or a manifesto that law need to expand, if it is not perhaps already doing so. But as we'll see, it's a necessary thing that law and society with the ampersand exists, based on her conclusion that we'll see very soon. Very exciting, I think. So therefore, this chapter will provide a brief survey of the different interdisciplinary approaches of historical study of law and explore both halves of this dyad, law and society, and explain how growth put pressure on the conjunctive metaphor long used to describe the relationship between law and what is not law, such as society, economy, polity, and others. And therefore, it will suggest the nature of law and society approaches to history are in great deal to do with what practitioners of historical study of law conceptualize as required of the ampersand or whatever metaphor one might put in its place. So that's what we'll cover in this chapter, but as my main takeaway is that this ampersand is necessary, and law and society is necessary, but also in many ways inevitable. So section 2, titled A Brief Interdisciplinary History of Interdisciplinarity in Historical Study of Law. So this is in the Oxford Handbook of Legal History, so we're taking specifically analysis of law and society's effect on legal history. So law and society as a field of study and approach had its seeds in Roscoe Pounds, who is considered one of the first realists. Contrast between law in the books and law in action in the early 20th century. And this was basically realism, which is bridges law in the books to law in the action, whereas the formalists could be seen as just law in the books. Its first heyday was in the 1920s and 1930s, when Robert Gordon quipped, "Much of Columbia faculty dreamed that every course might be partly one of sociology," and in his Historicism in Legal Scholarship, published by the Yale Law Journal in 1981. So by the 1920s and 1930s, almost every legal scholar, according to Gordon, who wrote many years later, was dreamed that every course might be partly one of sociology. So sociology had kind of gotten into every law course as a result of legal realism. It did not widely and enduringly embrace the empiricism then, but around 1960, sociologists, political scientists, and anthropologists embraced social legal studies with gusto, with the founding of the Center of Law and Society at Berkeley in 1961, and the Law and Society Association in 1964. They later held its first annual meeting at the American Sociological Association in 1964, and then met the American Political Science Association, American Anthropological Association, and Association of America. So perhaps it started with Roscoe Pound in the early 20th century, and then in the 1920s, all these legal academics perhaps wanted their courses to have sociology. Then by 1961, there were these large organizations specifically dedicated to bringing sociology into the legal field and applying it to other fields as well. It did not widely, and then in the law schools in 1965 started having many conferences with their perspectives of other than analysis, and there was a synthesis of legal doctrine was still, however, taught. So it's sort of a growing trend, seen as a wave, but somewhat of a primarily consistent wave. And specifically on legal history, which was had a distinct law and society emphasis on context when studying history of the law, was pioneered by J. Willard Hurst at the University of Wisconsin, where Gordon famously called evolutionary formalism, which is using legal history with legal law and society emphasis, and law, and was therefore an instrument of public policy used to achieve economic goals that could be studied using historical version of social science, empirical methods. Therefore, contract law and economics regulation affected by railroads, canal companies, or business corporations. So this law and society inevitably brought legal history, because if we're looking at society, we sort of have to look at legal history, and particularly some of the primary topics were how railroads, canal companies, and business corporations were influencing society through history, which were influencing law, which is somewhat of a causal relationship, which we'll see as the causal relationship can go both ways, and therefore necessitating the ampersand. So therefore, legal histories became important members of law schools, as well as economists, sociologists, and political scientists, philosophers, and critical theorists. Theory, empirical studies, and law and economics became even more influential in legal scholarship in the 1990s, however, than legal history. So she does note that legal history did kind of come as an inevitable factor of law and society, but primarily predominantly empirical studies and law and economics were the primary applications of law and society. The number of law schools, furthermore, during this time, hiring PhDs, even in lieu of Juris Doctors, exploded in the 1990s and 2000s. So suddenly law schools are hiring many PhDs, some that are not even having not even received their law degrees in their faculties as a result of this law and society movement, as a response to realism, which was a response to formalism, and the importation of professional controversy and methodology debates came with it. So if all these different PhDs coming from different fields, they all have different methodological preferences and perspectives. Therefore, the early growth of social legal history in law schools in the late 1970s and early 1980s coincided with the creation of one of the most significant cauldrons of intellectual ferment of law, which is called the critical legal studies around the 1970s, late 1970s and early 1980s. This critical legal studies, or CLS, often abbreviated, was influenced deeply legal history, where scholars use history to gain a critical foothold on contemporary doctrine and correlated doctrines, and therefore doctrinal change, and therefore they favor the showing that it favored the interests of wealthy and powerful influence of economic and political change. So legal history was used by critical legal theorists to show that doctrine was the result of favoring the wealthy and powerful. So critical legal studies was a further force, kind of a result of law and society that further favored socio-legal studies. Along with or just after, the crits, they're called the critical legal theorists, the feminists' critical race theory and queer theory, the notion that personal is political, therefore with applied legal historical scholarship too. So once again, law and society, so necessitating legal history, are all necessarily social legal history. And therefore, the law in the books, or formalism, was insufficient and therefore needed law in action as well, derived from legal history to law and society to law in action. As for law and humanities, in the 1970s also grew as legal scholars embraced post-structuralist theory and as departments of English and literature began to write about the law. So also in the literature departments and English departments started to embrace the law as well, not only in poems, novels, and plays, but a series of texts in their own right. I think a valuable video to watch would be my video lecture on Simon Stern, who's also featured in the Oxford Handbook of Legal History, who covers law in literature, from the professor at the University of Toronto, Faculty of Law. She also notes that the Law and Literature and the Problems of Interdisciplinarity by Jane B. Barron is a great article to read. The new historicism also grew as a movement or method of legal studies, and law and literature had its own problems with its conjunctive metaphor. So once again, like this law and society, if it's murky, what is law and society? Thus, law and literature is also murky too. Is law doctrine, for example, a casebook's not literature, and is literature, does that not imply law? I think that's quite revealing as well in Simon Stern's chapter and work. And Bernadette Mailer said that this formed a new love triangle between law, literature, and history. So this force also brought history into the law schools as well, as a result of law and society, which brought law and literature. Finally, law and society, enthusiastically embraced by colonial and post-colonial legal studies, naturally invited historical methodologies as well. So another big trend in the law schools was this colonial and post-colonial studies in law schools as well. For example, Sally Engel Mary began an ethnography of colonial law in Hawaii by examining 60 years of local records, but she constantly expanded the context she considered, therefore kind of a law and society, and therefore it turned from an anthropology into legal history. So a lot of these law and society, or law and anthropology, inevitably have legal history in it. Therefore, colonial and post-colonial legal studies also challenge American or Western notions of law by inviting overlapping laws of colonizer and colonized, a legal pluralism, further advocating for this variability in law itself, and the heterogeneous religions, customs, and systems of state and international laws to govern colonies, so also its variability in society, social forces. And Lauren Benton calls these the accommodation advocacy within system, or the subtle delegitimization and outright rebellion were the ways the conquered and colonized sought to respond to the imposed law of the colonizers. So there's all these forces besides law that was necessitated by law and society, not just law. You can't just look at law to understand colonial and post-colonial studies, but once again, it inevitably brings legal history as well. Moving to section 3, titled The Expansion of Law and the Expansion of Society, so the expansion on the two sides of the dyad. So the origins of social legal history, says, as shown, is a normative expansion. So 2 is the evolution that we will now look at. So an expansion, but it was also an evolution, a change. There are, she says, with exclamation marks, more scholars, more disciplines, more methods, more subjects, and both sides of the law and society dyad grew dramatically in the 1970s onwards, even as methodological pluralism as its defining feature was the only thing holding the enterprise together. So if they did not have this methodological pluralism, it would have all collapsed into just pure pluralism. And this continued the expansion of the meaning of law is to be the most significant feature of legal history in the past half century. The critics of she then cites Henrik Hartog's, who wrote the article Pigs and Positivism, which shows that pigs in the New York streets, where there was a discussion of whether the pigs should be allowed in the streets, but it was largely driven by social forces, or perhaps the wealthy who did not want to have pigs in their streets as a sort of class thing. So therefore there was historical and political questions brought in this 1970s era. On the other side, on the law side, the American law schools were increasingly interested in canon law, Islam, and therefore the Western European division of state law and religious law also brought further pluralism on the legal side. And furthermore, the social histories published in the 1960s, 1970s, and 1980s showed that law inflected studies could be seen as bottom up, which would be the social side, especially in the labor histories such as slavery, migration, and colonization, further strengthened the society side of the law and society dyad. And therefore, slavery is both a social and a legal institution. But here we're actually starting to see a difference between law and society, in that perhaps society could be seen as a bottom-up approach and law could be seen as a top-down approach. But there's a lot of overlap too, because law could be built bottom-up and society can also be built top-down. Next, she references Rebecca Scott in her work published in 2008 on post-emancipation, and she cited the needing of a correspondingly broad lens, where she studied Cuba and Louisiana, in that they needed to broaden the lens to not just study law, but also to study social factors. Christopher Tolmans, one of the editors of the Oxford Handbook of Legal History and a professor at University of California, Berkeley, where Catherine L. Fisk also studies. In his work on the first English settlement, the Civil War, showed that there was a formative conjunction of law and colonizing, published in 2010. So there was a conjunction of law and society element in his work as well. And in Michelle McKinley's Fractional Freedoms, Slavery, Intimacy, and Legal Mobilization in Colonial Lima, from 1600 to 1700, it explores the fertile space of law on the books and law in action, which was something that Pound brought with legal realism, and she publishes in 2016. So just here are some manifestations of law and society being linked and applied with legal history. Therefore, methodological pluralism, as long as rigorous or persuasive, anything is in ampersand, so they could just get on with their work. They're not defining their work as social studies, or they're not defining it as legal studies. If they just call it law and society, they can sort of get on with their work and find the really important conclusions that these scholars have found. And therefore, it stretches the field almost to a breaking point, and in the end, one cannot neglect the causal relationship, in that the role of society in law and law in society. So there's a causal relationship as well that cannot be neglected. And it would be wrong to, so therefore, is it wrong to imagine it as a dyad if this difference is so murky and there's such a causal relationship? And does the ampersand reinforce the idea of separation where it doesn't even exist? And if so, does this constrain the idea of law by separating it from law and society if law is fundamentally the same as society? And furthermore, this is particularly problematic as history, unlike economics and sociology, there's no consensus methods except rigorous research and careful reading. So in the field of history, where there are no consensus methods, and you're discussing law and society, then it's entirely murky, and therefore specific definitions might be more helpful in this area. And it struggles particularly with the question of law's autonomy in relation between law and outside the law. So whereas if you're doing law and society in the context of economics, there are specific economic structures you could follow so to define what is economics and what is law is easier to define, but in history it's even more gray area. So it's three murky factors all bundled together. And now she says, in the next section, we will now turn to the debate on how law and society relate to one another. So are they the same, and why is it structured in this way? So the title is, this is section 4, titled In and As, Relationships and Causal Claims, and this is the last section before the conclusion. So thank you for following along thus far. So the growth in law and society scholarship in the 1970s, there was caused by an increase in the functional and empirical claims about law and legal change, and it was no longer acceptable for elites to write doctrinal works neglecting social change. And it could no longer be viewed as an autonomous system. So there had to be this social element caused by likely legal realism. Hearst said, we should study causal interaction of legal and non-legal institutions in control of affairs. So that he notes that we should study this causal relationship. But the critics, or the critical legal studies theorists, disturbed the accepted varieties of origin, functions, and evolution of law. And according to Rita Birla, shows that this put the existence of international agency up for grabs, and historical inquiry in law in trouble. So if critical legal studies is really breaking down all these fundamental factors, then it even becomes more murky. And historical inquiry in law is even in more trouble with the incorporation of critical legal studies. And therefore, she says, Catherine L. Fisk notes, critical legal studies produce no replacement for the problematic law and theory it undermined. So if we're getting rid of all this theory, then now we have perhaps three terms that have no specific definitions. So the law and blank framework survived in part, she says, because the conjunctive metaphor, that paper, and therefore they could just paper over claims of causation, because I think it's definitely true that law affects society and society affects law, but just by putting them together we can get on with the research, essentially. And therefore it's conveniently vague and mutually constitutive, and it was more productive to just move on, essentially. And after critical legal studies, much of legal history was vexed with law as ideological superstructure or a foundation, and therefore this flexibility might help, and therefore determined by external forces or cause itself. So there was this discussion, is it affected by outside forces, or is it the effect itself? But now it's dismissed as laws embedded in society and vice versa. So just by having this law in society, it kind of solves the question as saying they are inevitably linked. And legal history does not, as social legal history, attempt to use empirical methods to show the effects in certain variables, such as regression. So there's not even too much work in this area that in endeavoring to show the causation. So one perhaps could show that certain variables cause changes in law, society affecting law, or law affecting society through regression analysis. But Catherine L. Fisk is alluding that this is probably not very meaningful work, because I think they inevitably cause each other, and therefore linking them with this ampersand is helpful. And this contingency and complexity remain, but is pushed aside in favor of narrative. And in fact, narrative is admired for itself, so allowing us to move on with this. And therefore, critical theory left scholarship on creaky, non-empirical foundations. So social legal history in particular was lacking, as requires social context to examine law. So critical legal studies really did write this social legal history. But if we just have law and society, it helps to have just essentially group them together so we can apply history and find its implications on both law and society. So what significance of the ampersand, if not habit alone? The reorientation of thinking from socio-legal history, the difficulty of law and society rather than as distinct from it. So if we had not incorporated law and society, they would not be seen as distinct. So although it's hard to define what the difference is between law and society, which I think perhaps the definition is top down or bottom up is one way of describing it, but the fact that they are separated has its connotation. And the persistence of the perpetuity of law's autonomy and lawyers and law professors' expertise. So it also has this sort of elevating of law once again. If we just called law society, if it was just like all the other social sciences, it would degrade the value of lawyers and law academics. And therefore, that law is something distinct from simple exercises of power by powerful government officials. According to Hearst's seminal 1942 essay, he said he was troubled about the question of authority, responsibility, and exercise, and therefore law as distinct, it endures because of legal realism is preferable to that advanced by economies that have tried the alternative, such as Germany. So the fact that law is something distinct from the power exercises, that law is a separate field from, like, for example, political science, is an important note that has been attempted in other jurisdictions, as we discussed in previous chapter, that in Germany they study statecraft. Statecraft is the primary degree leading to work as a public servant, which incorporates law, political science as kind of a mesh, whereas in the United States, law is a very distinct field. So by having law and society as separate terms, it has this liberal effect. And therefore, for example, she says many scoffed Justice Roberts when he became Chief Justice Roberts of the United States Supreme Court, in saying that he was merely an umpire who is objectively making decisions. But however, she notes that no one really wants to abandon the idea that law is a set of principles that constrain state and private power. So although people scoffed at it, there's still a need to have law separate from society. So it's very important, this term. And therefore, it may not be desirable or possible to free legal history from law and society paradigm, but there are still many projects are possible, such as the 3 symposia by the University of California Irvine Law Review, titled Law as ... as well as where Christopher Tomlins was the convener, the objective to employ history as an interpretive practice. So there's one application of law and society on history, as well. For example, Marianne Constable, who I previously covered, has the chapter Law as legal texts, which also apply legal history, as it's included in the Oxford Handbook of Legal History. As well, Christopher Schmid has law as consciousness in his work on civil rights movement. So there are a lot of law as others, so not just law as society, but I think these could be seen as perhaps subsets of society in many ways, but they all incorporate history as well. And therefore, Christopher Tollins also has almost what's called a law as technology in his Freedom Bound as a means of doing and making do. So law is almost as a tool. But this alludes to the fear of AI. So if law is a technology, or law as a technology, then is it out of control? Is it out of our control? And therefore has negative implications. So that's essentially what she's saying here, is that if we called it law as society, it would have had inevitably implications, as does law as text, law as technology, and law as legal laws, and generally many things, according to the University of California, Irvine. So it's important that it is an ampersand. And therefore, this summary of legal texts that she notes Robert Gordon's Pocket Guide to the common and exotic varieties of the social legal histories of America. She says this is just kind of an overview of some of the ways that law in society, or its subsets, law as, can apply to legal history. But she humbly says that her overview is less analytic and probably less staying power than Robert Gordon's, but I think she did a very fantastic job, at least from my perspective, in covering all the ways that law as society can be implemented that incorporate legal history. So, moving to the conclusion, so titled The Inevitably of the Ampersand, with a question mark. So she says, law in society originally was a type of legal history associated with J. Willard Hurst, and it is now practiced by almost anyone at an Anglophone university who claims to be a legal historian. So it started as a type of legal history, but now it is almost all legal historians apply law in society. And that's kind of, as we saw, it's an important just to separate law and society. I think that's one of my primary takeaways of the terms. And this has been a good thing for legal history and American law schools by opening the doors to the dominant form of disciplinarity, and the expansion of faculties from 1980 to 2008 has been tremendous. So by having this law in society, it's been very good for legal history, but also good for law schools as well, because by incorporating interdisciplinarity, law and society, or law as, you can have more professors with specializations and more funding as well. And law students no longer need to go to the history department to learn about history. They can stay within the law schools, and it kept the legal historians in conversation with a broad range of scholars as well. So if they can also learn about economics, or learn about many other things as well, or sociology, etc. Therefore, she ends with this quote, "If one believes history can ever tell the truth about the past, they must study the context." And therefore, the ampersand, whatever it means, indicates, there's a little bit more to go after, but ampersand, whatever it means, indicates should be thinking about the nature of law and its relationship to whatever aspects of human endeavor are relevant to the topic. And it would be unfair to leave the impression that the conjunctive metaphor has been a constraint on sociological history. So the ampersand has not been a constraint by separating these two. It's in fact been helpful. Instead, it's been an enormously empowering way to imagine the law is what the law is and how it should be studied. So I think one of my primary takeaways is that law is separate from society, but it's important to connect it with the rest of society. So a realist idea. And rather than prospering study of the ampersand, this essay meant to suggest the field of socio-legal history is broad and perhaps growing broader. Lastly, she says, and that is a good thing for those who either like to read or write about law, history, or whatever it may be that unites them with the rest of human experience. So very important thing, very important form of scholarship, and a growing field as well. At least up until 2008, she notes, so perhaps 2008 was one of the large recessions, so perhaps it's growing again now. But nonetheless, social legal history has been growing as a result of law and society, and this term is very important, and it was not her purpose to discuss too much about the ampersand itself, but in doing so, she hopes that you see all the opportunities for legal history in law and society. So I hope you enjoyed this chapter as much as I did. I thought it was absolutely fascinating as well to discuss the slide, and then we'll discuss Catherine L. Fisk more in the comparison. So her institution is the University of California, Berkeley School of Law. Her positions are the Barbara Nachtrieb Armstrong Professor of Law, as well faculty director for the Centers for Law and Work, and the Law and Technology, so the Center for Law and Work and the Center for Law and Technology. So she's the faculty director for both. So very important positions and very important at a very important legal institution. So the same that Christopher Tomlins is at as well. So as we saw, also she referenced him quite a bit as well. As for the images, we have Princeton University, where she received her Bachelor of Arts, University of California, Berkeley, where she currently works and received her Juris Doctor, and the University of Wisconsin, where she received her Master of Law, her LLM. Her areas of interest include employment law, labor law, civil procedure, and understanding of the U.S. legal profession. Suggested readings include her books, such as Writing for Hire, Unions, Hollywood, and Madison Avenue, published by the Harvard University Press in 2016, and Working Knowledge, Employee Innovation, and the Rise of Corporate Intellectual Property, 1800 to 1930, published by the University of North Carolina Press in 2009. As per the quotes, law society vis-a-vis historical legal research means at least two distinct though interrelated things. And then going forward, in both these senses, law and society has been so significant that almost no sophisticated work of legal history published in the last quarter century has escaped its influence. Next quote, law and society as a field of study and an approach to the study of law has its seeds in Roscoe Pound's contrast between law in the books and law in action. Next quote, law and society was originally a type of legal history associated with J. Willard Hurst, but now it is practiced in one form or another by almost every academic in an Anglophone university who claims to be a legal historian. Next quote, by proposing the ampersand itself to be an object of study and by cataloging some of the ways in which it has become so, this essay means to suggest simply that the field of socio-legal history is broad and perhaps growing broader, and that is a good thing for those who like either to read or to write about law, about history, and about whatever it may be that unites them with the rest of human experience. I thought that last quote was particularly nice, and that's what necessity of society is, necessity of history, if that helps them unite them with human experience. So once again, her chapters in part 3, Perspectives, Legal History, and Modern Legal Thought. It is chapter 26 of the Oxford Handbook of Legal History, and it is ampersand, law, society in historical legal research. So as for the comparison between Dan Priel and Catherine L. Fisk, so in terms of their geographies, Dan Priel was, at least he did his undergraduate degree at the Hebrew University in Israel, so was he born there? Perhaps it's, I'm not sure, but I think that's likely that he's from Israel. Nonetheless, he moved to the United Kingdom, to go to Oxford for his graduate studies, and now he's currently in Canada as a professor. Whereas Catherine L. Fisk has stayed in the United States. However, she started at Princeton, which is east in New Jersey, and then she moved to Berkeley, which is in Los Angeles. However, she also went to the University of Wisconsin for her Master of Law, so it's kind of like she at least moved from east to west, whereas Wisconsin is actually kind of more central east, but it's actually considered the Midwest United States. But my guess, I might be wrong in this guess, but perhaps she's originally from Wisconsin. Maybe she went back to do her Master of Law, but close to home. If that hypothesis is correct, she has moved from the Midwest to the east to the west, and some deviation amongst that. But nonetheless, Dan Priel has moved perhaps more in terms of countries, but perhaps Catherine L. Fisk has, well, I guess they both moved maybe about similar amount of times, but nonetheless, none of their their geographies overlap. However, both of them were discussing specifically the American education or legal education system. So although Dan Priel never actually studied or taught in the United States, he did cover the United States, which, however, Catherine L. Fisk studied in the United States and is covering the United States as well. In terms of degrees, Dan Priel has a PhD from Oxford. However, Catherine L. Fisk does not have a PhD, but she has, pardon me, has a Master of Law, which the Oxford BCL, the Bachelor of Civil Law, is considered similar level to the Master of Law, but nonetheless, the Dan Priel does not have a Juris Doctor, but he has an undergraduate law degree. So in Israel, you can do in your first degree, you study law. So different in that sense, but nonetheless, Dan Priel is a doctor, whereas Catherine L. Fisk, technically a Juris Doctor, is a doctor too, but it's takes less time. But in terms of time in academia, they both spent significant time and at multiple institutions. In terms of books, Catherine L. Fisk does have more. She has these two books by herself and 4 books she's co-authored. However, Dan Priel has 1 book, however, and many articles. However, Catherine L. Fisk has over 100 articles, but I think Catherine L. Fisk has been in the academic community for longer, so more opportunities to produce more writings. Interestingly, they both clerked for an appellate court, whereas Dan Priel clerked for the Supreme Court of Israel. Catherine L. Fisk clerked for the United States Court of Appeal, Ninth Circuit. So while Catherine L. Fisk did not clerk at the United States Supreme Court, which would be seen as parallel perhaps to the Supreme Court of Israel, it must be noted that the United States is much larger. So they're both, I would say, quite similar in terms of jurisdiction. So, and they both have, I think, in terms of practice, I've seen more about Catherine L. Fisk did have quite an extensive legal career too before she went into legal academia, whereas as for Dan Priel, besides his clerkship, it seemed like he went pretty soon after into legal academia. In terms of their areas of study, both of them have a very strong understanding of legal realism. However, Dan Priel focused a bit more on it in his chapter. His chapter is predominantly on legal realism, whereas Catherine L. Fisk discusses law and society and its impact on legal history, which is has been influenced by legal realism, but she does not focus on legal realism itself. So different context here. In terms of their interests, Dan Priel is more interested in doctrine and theories, such as and private law, such as tort law, and also restitution and the welfare state, whereas Catherine L. Fisk has more interested in labor law, and she also currently does much pro bono work and serves on many boards of directors, whereas I did not hear of Dan Priel doing much pro bono work or being on many boards, but perhaps he does, or perhaps he will. So that is another distinction there. They both are also talking about, they're both in the section of modern legal thought, so they're both covering modern concepts, whereas Dan Priel is talking about legal realism today. Catherine L. Fisk is talking about law and society today. But most common, and as common within all the scholars within the Oxford Handbook of Legal History, they're both fascinated in legal history, which I think is actually, although legal history does come into all law, a lot of legal scholars are not specifically interested in history, unlike these two who do have a specific interest in legal history. And I think also they both have also much planned for the future. I think Dan Priel, they both have quite a, I'd say much their career ahead of them. They're both producing much work as we speak, and I think there's much, at least I know I look forward to seeing from them. So thank you very much for watching this video on the Oxford Handbook of Legal History covering Dan Priel and Catherine L. Fisk and their respective chapters. I hope you enjoyed. Thank you so much, and I hope you can continue to support.